And I just want to talk about something a bit more technical. You might even call it secular, but it's how do you establish your ministry on the right legal foundation? We've heard so much about foundations this morning and this afternoon, so I want to take that as a topic. I have some slides. I hope they're going to come up. Some of us might have already registered our ministry with the government. Some of us might be planning to do so. Some of us might need some clarity along these lines. And that's the essence of this short presentation, maybe 20 minutes at the most. Please don't leave. We have a time for you to share testimonies, ask questions, for us to receive feedback and give further perspectives, and then lunch will be served. So please do not leave. Okay, are my slides coming up? It's like the slides are not quite ready. Let me see if I have. I can kick off with my notes. So I've called this church, you can take notes if you want, church establishment and administration under Nigerian law. That's the topic, church establishment and administration under Nigerian law. And I'll be looking at three basic things. There's an act, a legislation called the Companies and Allied Matters Act that regulates associations such as churches when they choose to register trustees. It was, first of all, passed in the year 1990, and 30 years later, being the year 2020, it was amended, or a new one came out. Also, we look at corporate governance and regulatory compliance, and then finally, government oversight. Now, let's start with the fundamental rights to worship. We have a foundational legal document in Nigeria called the Nigerian Constitution. And in Section 38, the Constitution provides that every person shall be entitled to freedom of thought, conscience, and religion, including freedom to change his religion or belief, and freedom to manifest and propagate his religion or belief in worship, teaching, practice, and observance, either alone or in a community of other people. And so this guarantees our right to worship and exercise or express our faith. There's also the freedom to associate. Section 40 of the Constitution provides that every person shall be entitled to assemble freely and associate with other persons. And in particular, he may form or belong to any association for the protection of his interest. Now, if you have an association that is already established by the Constitution, that you can do that. But to have it registered, you must appoint what is known as trustees and apply for those trustees to be incorporated by the Corporate Affairs Commission. And that's governed by Section 823 of the Companies and Allied Matters Act. It provides that where two or more trustees are appointed by any community of persons bound together by custom, religion, kinship, or nationality, or by any body or association of persons established for any religious, educational, literary, social, and other purposes, they may, if so authorized by the committee of body or association, apply to the commission in the manner provided for registration. So first of all, you have an association. It appoints trustees, and those trustees apply for registration. That's the process. So you can have your assembly right now, whatever, your congregation. You decide you want at least 2 trustees. That's the minimum. Obviously, as the founder, you will be one of the trustees, and then somebody else that you trust. You see, that word trustee is very important. It means you trust the person. So that's the process. You then apply for registration of those trustees. Okay, so the minimum number is how many? 2 trustees. It used to be 1, but now it's 2 or more trustees that apply for registration under Section 823 of the Companies and Allied Matters Act. And that gives legal recognition to your association. The trustees represent the association. They are they become a body that is legally recognized by government, that can speak for the association, that can be sued or sue in a court of law, that can hold property on behalf of the association. So if your ministry you want to hold land, short of holding it in your own name, this is the proper way to do it. You appoint trustees, yourself and at least one other person, as the founder and one other person, then apply to the government for registration. And then those trustees will form a corporate body that will then hold the land on behalf of all the members. Because you see, the membership of the association changes. Like we just said, Apostle Chike was teaching about people relocating or leaving your church. So the membership it ebbs and flows, but the trustees remain the same, and they hold whatever assets for the benefit of whatever the membership is at any given point in time. And that's the essence of that trust arrangement. So from the date of registration, the trustee shall become a body corporate by the name described in the certificate, and they shall have what is known as perpetual succession. You want to write that word down, or that phrase, perpetual succession. They can have a common seal if they wish. It's not compulsory, but you can have a seal. And then they have the power to sue and be sued in the corporate name. And they also have the power to hold, acquire, transfer, and dispose of property, whether chattels or real estate, landed property. So perpetual succession enables a corporation to manage its affairs and hold property without the necessity of perpetually conveying the property over and over again. So whatever that body is called, even when you pass on, once you have trustees in place, that body can continue to hold that property and continue to act for the benefit of its members. And so you have church organizations that are still running even though the founder has passed on, because they were incorporated, or the trustees were incorporated. That's why that happens. So this is part of laying the right foundation for your ministry. Okay, so legal personality means that the trustees can operate as a person at law. So just like you have your own individual personality, that corporate body that is registered is a recognized legal person. That person can act as just has rights and duties and obligations just like any other legal person. Let's go into quickly. I've spoken about holding land. I've talked about making an application to the Corporate Affairs Commission. Now, each association that wants to be registered in the way I've described must have a constitution. And one of the most important aspects of the constitution are the aims and objectives of your association. So you must carefully think, and we've been talking so much about that. What is your vision? What do you see in the future? What do you want to be known for? What's the identity of the association? Now, you put those objectives in the Constitution. Usually you put also your vision in the Constitution, and then you put other governing principles. What's the executive? What are the subunits of the association? How will it be run? How will financials be handled? How would you change the trustees? If you want to replace a trustee, how would you go about it? Those kinds of things. So the church constitution is a very important document that is submitted to the government, and you can also amend it if you want, and there's a process for doing that. The trustees are also, you must also provide all the pertinent information of those trustees. It becomes something that is publicly searchable. Anyone can go to your record in the Corporate Affairs Commission and see your constitution, see your trustees, see what you believe in, see your objectives, and so on. So you actually become publicly accessible in that sense. So the process is as follows. You first of all choose a name. So what do you want to call the association? What's the name of your ministry? And you often would come up with 2 or 3 names, because you cannot have a name that is identical with an already registered name or so closely resembles that name that it will deceive the public. And once you've chosen a name, you kind of do a search to find out if it is available, that is, if there's no similar name already registered. If you pass that stage, that phase, that means that the name will be reserved for your use for 60 days. You then take out a newspaper publication telling the whole world that you have applied to the Corporate Affairs Commission for registration of this body, put the name there, and then you mention the trustees, and you give the public 28 days to object to the registration. Now, while the 28 days are passing, you gather all the other materials that you need for the filing. And I've mentioned some of them. That's when you put together your constitution and do other things, complete the necessary documentation. Then you file the application once the 28 days have expired, and within about a month you will obtain, or less, you obtain a certificate of incorporation listing the trustees and giving yourself a unique registration number or incorporation number. And from that moment, the trustees can begin to act, can enter into land transactions and do other things on behalf of your church or your ministry. So there's also an aspect of corporate governance. The law expects your church or ministry, once it's registered, actually any association at all, but once it's registered, it now becomes kind of exposed to the government eyes. You have to keep proper records of accounts. So that's very important. That's covered by Section 846 of the Companies and Allied Matters Act. Now, if you have any bank account that you are not operating, in other words, you have to monitor all, you obviously can open bank accounts in the name of the ministry once it's registered. But if you are not operating a bank account, the law mandates that you close it, or guess what? The government can close it and take the money. Now, this was done there before 2020. Just somebody come up with an idea that there must be idle funds lying around in bank accounts of church organizations, and they want to be able to just take that money. So be very careful, be very diligent about monitoring your bank accounts. That's Section 842. Then there's a biannual statement of affairs that should be submitted. In other words, the fact that this is a charitable organization, as it were, a religious organization, is not a for-profit organization, does not mean that you do not need to keep accounts or be accountable. In fact, you're supposed to prepare statements of affairs, showing how much money came in, how you spent the money, and things like that. And the senior pastor has said, I think my senior pastor has said in passing that our accounts in this ministry are audited. So that's really the proper way to do it. You must keep accounts. It costs money, but this is the proper way to do it. This is covered by Section 845 of the law. And then you have to preserve those records. Every such body must preserve their records for a minimum of 6 years. So we're now in 2025. You should have accounts of 2019 to 2025 preserved. So if anyone wants to investigate you, typically they cannot go back beyond 6 years. That's generally speaking, except there's some exceptions to that. But you must maintain 6 years records of your accounts. And also there's a requirement to file an annual return at the Corporate Affairs Commission every year. Okay, and you can also, like I said in passing, file for changes to your, we call them alterations, changes to the Constitution, changes to the trustees, changes to your aims and objectives. All those changes can be filed from time to time. Now, there's a provision for government oversight which has been overturned by the law, by the courts, that there's a limit to how much government can interfere in these bodies, because the law was set up so that government can come in and even remove a trustee if they feel that the person is acting fraudulently, but the courts have said this is not permitted. So that's my short presentation on establishing and running and administering a church organization under Nigerian law. So the two main points I want to leave with us is that registration, though it has been described this afternoon, enables your ministry to continue in perpetuity, enables you to hold land in the name of the trustees and to act as a legal person recognized at law. And secondly, the other aspect is compliance and governance. You have to sustain your ministry from the legal standpoint by ongoing monitoring. I mentioned bank accounts, I mentioned filings, I mentioned keeping of proper records. All of those ensure that the sustainability of your ministry exists from a legal standpoint. You want your ministry to be sustainable from a legal standpoint by observing these compliance and governance practices. Thank you so much for your attention.